At the end of the day, defining assumptions and setting expectations is on us as the lawyer. If we don't take the time to do it up front and we don't take the time to put it in writing in our engagement agreement, we really only have ourselves to blame. Welcome to A Different Practice. I'm your host, Lauren Lester, and I'm obsessed with all things business, well-being, and optimizing the practice of law for solo and small firm lawyers. I started my solo practice right out of law school, built it from the ground up, and now work 4 days a week while earning well over 6 figures. I'm here to share tangible, concrete tips and resources for ditching the legal profession's antiquated approach and building a law practice that optimizes growth and enjoyment. Think of this as grabbing coffee with your work bestie mixed with all the stuff they didn't teach you in law school about how to run a business. Pull up a seat, grab a cup, and get ready to be encouraged and challenged. This is A Different Practice. A good engagement agreement is the bedrock of a positive client relationship. It sets expectations up front and helps ensure you and your client are on the same page, quite frankly. And when you've done a great deal of work determining the value that you're providing in solving the client's problem and how that value translates into your pricing, it's important to properly memorialize those components in a comprehensive engagement agreement. In this episode, I'll cover 6 common mistakes made in engagement agreements and how to fix them. I'll provide you with some sample language to help get you started, which will also be included in the show notes so you can easily copy and paste and customize it for your own firm. Before we get started though, I want to be super clear about something. Because every practice and every state is different, please review and start with the local rules of professional conduct where you practice to make sure you're complying with those requirements. And of course, if something I share doesn't jive with your local ethics rules, follow the ethics rules. I don't think that should end up being the case since typically ethics rules are written to protect the public and we're focused on being client-centered here at A Different Practice, but just in case, don't be dumb. All right, let's get into these common mistakes. Mistake number 1, the engagement agreement is not memorialized in writing. Whether or not your local rules of professional conduct require engagement agreements to be in writing, this should be a standard practice in your firm. Every engagement agreement you enter into with a client should be in writing. No ifs, ands, or buts about it. If the reason you aren't putting every engagement agreement in writing is because you're having to custom create them each time and it's just taking up too much time, I totally understand. You don't want or have the time to add yet another thing to your already full plate. I've got good news though. There is a ton of technology out there that will allow you to fill in a few fields, click a few buttons, and generate a custom engagement agreement for a client in less than a few minutes. Some CRMs like Clio Grow have template creators built in. You simply add the standard parts of the agreement that every agreement will have, and then identify spaces where you'll fill in information particular to that client. When you're ready, you choose the right template, fill in the individual information, and the software sends it off to the client for e-signature. At this point, I have more than 24 engagement agreement templates for different case types and different scopes within those case types. It just made sense for me to do it that way because it means I simply choose the template and I'm sending it off in less than a minute. Another option to consider might be Documate, which will soon be called Gavel. Documate is nice because you can create your template in Word first and then design a custom form to capture those unique bits of information for a particular matter, and then set up in the template where that particular information should go. Documate also has conditional logic built in, so if you wanted to say include in your form a question about whether or not the client was going to use a payment plan, the flow could be set up so that if you check yes, that additional paragraph about payment plans is included, where if you said no, that language just wasn't included at all. That way you don't have to waste time adding or deleting certain provisions every time you create an engagement agreement. It simply happens with just one click. Documate also has e-signature capabilities built in. Now you might be thinking, aren't I just trading the time it takes to write the engagement agreement like I'm doing now to set up the technology to do it for me? Yes. You may very well be trading that in the short term. However, in the long term, there's absolutely no comparison. Once you invest in getting the system set up, you can create engagement agreements in literally a minute or two. That's how long it takes me at this point. It's well worth the investment for the return of having every engagement agreement in writing and signed by the client. And since having every engagement agreement in writing should be a non-negotiable in your practice, taking the time to invest in getting the technology set up should be a top priority. All right, mistake number 2. Failing to define the scope of the representation in the engagement agreement. This should be one of the first sections in your engagement agreements and include the very specific work or tasks that you will complete as part of your representation, along with any associated timelines and when your representation will end. And when I say specific, I mean specific. Include a list and write things out like drafting the petition for dissolution of marriage, drafting the summons, drafting a sworn financial statement, gathering and organizing your financial documents, exchanging documents with the other party, negotiating settlement, and answering any questions. From drafting pleadings to whom you'll communicate with and about what, to even just the administrative tasks that might be required. List those out so that it's really clear what's included and what's not. Some other factors to consider and spell out might be how many rounds of revisions are included, especially if you're drafting something. How much communication time will the client have with you? How many meetings are included? How are continuances handled? And how many proposals are included in the negotiation? The more detail you can provide, the better. To be even more comprehensive, spell out any tasks the client will still be responsible for. Maybe instead of your gathering and organizing financial documents, it's the client's responsibility to do that. Or maybe a particular package doesn't include your communicating with the other party, and instead the client's going to be responsible for talking to them. If it's a step or a component of the process that will be needed, but you aren't going to be doing it as part of your representation, it should be clearly explained to the client that that's what's happening. On that same note, if there's something that's not included in the scope, but could be something the client adds on, or is something that doesn't always happen in a case, but could come up in this case, you should list that too. Now, what could happen might be a pretty long list, so we don't want to overwhelm the client, but we do want to be transparent. Maybe you could categorize variables without having to list every single possibility. For example, I include language that says, the scope doesn't include representation regarding any other motion that might be filed, including for contempt or the appointment of a CFI. We all know that there are more than 2 types of motions that could be filed, but the 2 examples I gave are more common ones. And so if a not so common one comes up, especially if it's one that the other party just makes up out of thin air, I'm still covered because the language said any other motion, which the made up out of thin air motion would qualify under. In my engagement agreements, I also provide the additional cost for those out of scope add-ons. That gives the client a sense of the additional cost they might incur if things become more complicated. It also helps the client see from the beginning that dragging the case out or trying something just to see if it might work might not be the most cost-effective strategy. Sometimes what's not included is even more important to identify to avoid confusion. And if you plan to outsource any of the work, also be sure to disclose that as well. If you're providing limited scope representation, the Chicago Bar Foundation has a great resource called the Limited Scope Resources Toolkit, which has sample checklists, an engagement agreement, and other important information pertaining to unbundling. Definitely check it out. We've also included examples of detailed scope clauses in the appendix of the pricing toolkit, which is available for free right now at thepricingtoolkit.com. All right, mistake number 3, not spelling out when your fee is actually earned. Once again, consult your local rules of professional conduct to ensure you are in compliance with how your state handles earned fees. If you live in a state where flat fees are earned upon receipt, be sure to clearly include that information in your engagement agreement. And it's probably also good practice to specify how refunds would work so that if the work that you spell out in the scope isn't actually completed, it's really clear what portion of the fee would be returned to the client. Now, if you live in a state like I do, where flat fees are earned as the work is actually completed, including milestones and what portion of the fee is earned with each milestone is a great way to spell things out. So the first thing to do here is choose the milestones. And those you want to be either guaranteed to happen or ones that you control. For example, if you know it's guaranteed that there will be at least one status conference, that's a good milestone to include. If there might be a status conference, but it depends on the judge the case gets assigned to, that's more of a risk to include it as a milestone. What if it doesn't happen? Does it mean that that portion of the fee just isn't ever earned? Sometimes what I do when there's a milestone that may or may not happen is I add on an alternative. For example, I'll say, okay, if the status conference is finished, this milestone would be considered earned. But if a status conference isn't required by the court, this milestone would be considered earned either 90 days from the date of filing or after the court confirms that no status conference is needed in your case, whichever comes first. In that example, I would have picked 90 days because I know that's the statutory deadline for having those types of conferences to be scheduled, so I could be absolutely sure that after 90 days, I'm going to know one way or another. There's no ambiguity there. If there's not a known timeline that you could rely on, you want to write the milestone where you are in control of it happening. For example, this milestone would be considered earned when I draft the petition. If you write that the milestone is earned when the client signs the petition, you're now waiting on the client, who could delay things for God knows how many reasons, when in actuality, the vast majority of the work has actually been done. You're just waiting on a signature. If the client wants to take a while to sign, that's their decision, but it shouldn't affect the understood completion of a milestone. Once you've determined the major milestones for the scope of work in your engagement, you then want to assign a percentage of the fee to each milestone. This percentage should generally correspond to the portion of overall work completed in that milestone as compared to the total scope. So for example, if you assign 80% of the fee being earned just by drafting a petition, which generally occurs at the beginning of a case, that's likely not reasonable when the scope includes work through the entire case. On the other hand, if the entire scope of the engagement is simply drafting the petition, then saying that 100% of the fee is earned once it's drafted makes total sense. Colorado recently added to Rule 1.5 of its Rules of Professional Conduct and specified rules around flat fees and when they are considered earned. The comments even include a sample engagement agreement, which is really nice. So even if you don't practice in this state, consider checking out Rule 1.5H for a nice example that you could certainly build off of. That brings us to mistake number 4, not including assumptions that the engagement agreement is based on. Typically, before we get to the stage of writing an engagement agreement, we've talked to the potential client, we've listened to their goals and needs, and we've probably discussed with them some service offerings that could meet those needs. To determine what service offerings were best for that particular client, we asked them questions, we issue spotted, and we used the information that the client provided. That information in particular, those assumptions that we relied on, should be included in the engagement agreement. My engagement agreement literally starts with the assumptions. After thanking the client for choosing my firm, the next sentence is, "This agreement details the scope of our engagement, as we discussed," and then it goes on to summarize the situation, including the assumptions. For a divorce case, the rest of that sentence might sound something like, "You and the other party are looking to file for divorce. You've already discussed how you will divide assets and debts and a parenting schedule that works for your kids. You are looking to complete the process amicably and memorialize your agreements." The scope of work that I create for that client is much different than the client who walks in and the beginning of their engagement agreement reads, "You are looking to file for divorce. You and your spouse are not able to communicate in a civil way right now. You have not discussed the division of assets and debts. You don't believe there will be an agreement reached, and the court will likely need to make the final decision." Including a summary with the assumptions has two benefits. First, it signals to the client that you get it. You listened to what they had to say. You wrote it down. You summarized their situation and what was important to them. From the jump, you are establishing a positive relationship. Second, spelling out the assumptions you're relying on will protect you from doing more work than you were anticipating doing because an assumption turned out not to be correct. Should things change, say in our first example, we realize that there are some things the parties actually don't agree on, you've now had the foundation set to have a conversation with your client that additional cost may be incurred. We'll cover that part next. At the end of the day, defining assumptions and setting expectations is on us as the lawyer. If we don't take the time to do it up front and we don't take the time to put it in writing in our engagement agreement, we really only have ourselves to blame. It's not that hard to do. We just have to put in a little bit of extra effort. Okay, mistake number 5, failing to include a right to renegotiate clause. While not including assumptions relied on is definitely a mistake made in engagement agreements, when it's coupled with failing to include a right to renegotiate clause, the engagement agreement goes south real fast. Failing to include a right to renegotiate is a surefire way to make sure you start resenting the case and probably even the client when things take a hard left turn. And again, this is a mistake that's entirely on us. Luckily, it's super easy to fix because we're now going to expressly state the assumptions we're relying on in each individual engagement agreement. We're going to couple that with the language that explains if those assumptions turn out to be incorrect or if things just change, we'll come back to the client and renegotiate. This right to renegotiate clause springs into action when something like an unforeseeable variable arises or just the facts of the case change, requiring a change to the scope. Including this clause from the beginning sets the expectation that the scope may need to change and the client may incur more cost, so there wouldn't be much of a surprise if that actually happens. My right to renegotiate clause sounds something like this. This flat fee amount for my services is based on my assessment of your case given the facts you provided. Should your case become more complicated or require additional work, an additional fee will be required to cover the additional work. I will not address the additional work until a new agreement is signed and the deposit is paid. If you choose not to extend my representation to include the additional work, you understand it'll be your sole responsibility to complete it as required. Clear and direct, no surprises. I have never had a client push back when I've had to point out this paragraph and discuss a change to the scope. Now, they aren't always happy about it, especially when the reason that there's more work is because the other party is doing some ridiculous thing in the case, but they get it. And more importantly, they understand. That understanding comes from showing them that I understand their goals from the beginning and set the expectations based on them. Of course, if after speaking with the client, new terms for representation are agreed upon, they also need to be memorialized in a new engagement agreement that outlines the change of scope and a new fee. The cycle just continues. This brings us to our last mistake, number 6, not clearly establishing boundaries and setting other relationship-related expectations out in the engagement agreement. One of the biggest benefits to offering transparent and predictable pricing to clients is that they're able to contact you without being nickel and dimed. They don't feel like they're watching the clock. That being said, it also doesn't mean they have access to you 24/7. So no matter your practice area, including boundaries and expectations around communication with you and your team is an essential part of your engagement agreement. While proactively discussing communication expectations during the initial consultation is really good practice, at a minimum, they should also be outlined in the engagement agreement. Be as detailed as possible about the preferred method of communication, days and times you're available, response time, and just an overall volume. My communication provision sounds like this. Although I do not keep traditional work hours, I strive to respond to all communication by the end of the next business day. While I may communicate during non-traditional business hours, you agree to respect my time and only contact me during these times in an emergency, unless we have a previously scheduled appointment. If there is an emergency, please send a text message that begins with urgent, and I will respond as soon as possible. I also go on to describe that I typically communicate by email and that if the client has concerns about what they're sending by email, that they'll also have access to a secure client portal that they can use to communicate instead. In addition to describing how to communicate with me, I also include information about the amount of communication that's included in this particular representation. That provision sounds like this. The tasks under this agreement include up to 3 hours of communication time, whether by email, phone, text, or meetings. That amount of time is generally more than enough for the services included in this agreement. Should you want more communication time, you can purchase more depending on your needs at the following costs. I then go on to detail the additional costs and describe how that additional cost will be collected up front and held in trust until it's earned. Again, cycle continues. Similar language would also be included in the new engagement agreement that I have if they do purchase more time. I also confirm with the client that I will let them know when they're close to exceeding the included time so that they have a heads up before it runs out. While boundaries and expectations around communication is a major area to cover that includes several different aspects, other topics you might want to include in your engagement agreement include the responsibilities of and the expectations of working with your staff, your file retention policy, the use of cloud-based platforms, security measures or requirements that you have, payment policies, including how late payments are handled, what expenses the client will be responsible for and how they should pay them, and anything around just the logistics and practicalities of working with you and your firm. In essence, what should the client expect when working with you and what boundaries do they need to respect? Laying out these expectations from the beginning will create a solid foundation for your relationship. All right. Those are the 6 mistakes to avoid in your engagement agreements and how to fix them. To recap, every engagement agreement should always be in writing. Specifically detail out the scope. Explain when and how fees are earned. Spell out assumptions we are relying on, and include a right to renegotiate clause when those assumptions change. And lastly, include clear boundaries and expectations. I cannot overstate it enough. The more detailed, the better. Be specific while using plain language that the client can understand. Making these changes will help avoid issues, create a clear line of communication, and just help to establish a positive attorney-client relationship from the beginning. I've included the language that I shared in this episode and links to resources in the show notes to give you a great starting point. You can find them at adifferentpractice.com/podcast. Feel free to copy and paste and then tailor them to your firm's needs. Thanks so much for listening. Until next time, keep building. I'm over here giving you a virtual high five because you just finished another episode of A Different Practice. For more from this episode, head over to adifferentpractice.com/podcast for show notes and links to resources. If you found this episode helpful, let me know by leaving a rating wherever you listen to your podcasts. And don't forget to subscribe so you never miss an episode. If you're looking for even more practical tools to optimize your law practice for growth and enjoyment, be sure to sign up for our monthly newsletter. The link is waiting for you at adifferentpractice.com/subscribe. I can't wait for you to tune in next time. Until then, keep building a different practice.